Why is it a bad idea to plead guilty to a DUI charge in Florida without a lawyer? Well, there's one type of DUI case where there's absolutely no advantage to having a lawyer. Those are the cases that are so weak that the prosecutor realizes it and will either drop the case or reduce it to a lesser charge immediately. But there aren't many of those. The problem is that without a lawyer, you never know whether there was a viable defense. You have to have a lawyer to evaluate the evidence. Some of our best victories have started out as cases that looked like they simply could not be won. I've had many cases, for example, where a client was sleeping in the car and an officer knocked on his window and told him to roll the window down. That allowed the officer to smell alcohol and to start a DUI investigation. The client might be completely drunk, but that initial intrusion was illegal, and the officer never got any evidence to pursue the investigation until he ordered the person sleeping in the car to roll the window down. That was an illegal order, so none of the evidence can be used against the driver in court. A lot of times, when we have a case that's totally dismissed, it's because we won a motion to suppress evidence. If there is no reasonable suspicion of criminal activity to support a traffic stop, that makes the initial stop illegal, and all of the evidence that's a product of the stop becomes inadmissible at trial. There are a lot of times when a person can be merely tired or hungry or have low blood sugar and give the appearance to an officer that they're impaired by alcohol when they're not. It takes a well-trained eye to see the problems with a state's case. If you don't hire a good lawyer who knows DUI law, you may never even know that those problems exist.